Welcome back to Faith and Freedom 250, a series from the Herzog Foundation. Today, we're looking at one of the most important ongoing struggles in our nation, the fight for religious liberty. From the earliest days of the Republic to the Supreme Court battles of the 21st century, Americans have worked to preserve the freedoms guaranteed by our Constitution.
Religious liberties were among the very first rights protected by the First Amendment of the Bill of Rights. That founding document states, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." So important was religious freedom for the generation that fought and won the Revolution, it occupies a place of preeminence in our law from the earliest days of our republic. Even with this lofty status, the battle for religious liberty continues today. The 21st century has witnessed many landmark decisions from the Supreme Court that have profoundly affected these rights. The cases heard by the highest court were part of the long fight to combat the cases of the 1960s under the Warren Court, which emphasized a stricter separation of church and state, particularly in public schools. Religious groups fought back, and they won many important victories.
Among the first major successes came with the Zellman versus Simmons-Harris decision in 2002. This case ruled on the state of Ohio's school voucher system and allowed parents to use the vouchers to choose religious education as well as public institutions. Ruling that vouchers are awarded to parents and not institutions, the Ohio system did not violate the Establishment Clause of the First Amendment. This decision cleared the way for more states to adopt an education voucher system and strengthen the opportunities for religious schools nationwide. 2 years later, in Locke versus Davie, the court ruled that states could refuse to fund specific clergy training even if the state supports education funding in general. This decision was a disappointment for those seeking to expand religious protection.
Fast forward to 2012, and church autonomy was protected in the case of Hosanna Tabor Evangelical Lutheran Church and School v. EEOC. The court upheld a church's right to hire and fire ministers without government interference, protecting churches' ability to determine who would shepherd their flocks without government meddling.
Religious institutions won another significant victory after the passage of the Affordable Care Act during the Obama administration. In Burwell versus Hobby Lobby, the court sided with employers who operate their businesses based on biblical principles. At the heart of the argument was the ACA's contraceptive mandate, which conflicted with the religious convictions of many Christian-based businesses. The 5-4 decision relieved these businesses from compliance and greatly expanded free exercise protections under the First Amendment.
In Trinity Lutheran Church versus Comer case in 2017, the High Court ruled that churches cannot be excluded from public benefit programs solely because they are religious organizations. This decision ensured that religious institutions could access public funding opportunities without discrimination. One of the most widely covered cases came in 2018, Masterpiece Cake Shop versus Colorado Civil Rights Commission. The defendant, a baker, refused to make a wedding cake for a same-sex couple due to his faith. The plaintiff sued for discrimination. In a 7-2 majority, the court sided with the baker, affirming that Christians in business do have the right to operate according to their religious beliefs without government coercion.
Scholarship programs took center stage again in Espinoza v. Montana Department of Revenue in 2020. The court ruled that states cannot bar religious schools from scholarships based solely on their religious status. This landmark decision opened doors for Christian education students to fully participate in state programs. A similar case 2 years earlier, Carson versus Macon, applied the same principle to tuition assistance programs.
In a 2021 case, Fulton versus the City of Philadelphia, the court addressed whether a city could exclude a Catholic foster care agency for refusing to place children with same-sex couples. In a unanimous decision, the court ruled that the city could not do so, protecting religious freedom in public-private partnerships nationwide.
One final example of cases appearing before the Supreme Court came in 2022 in Kennedy versus Bremerton School District. The court examined whether a public school football coach could pray on the field after games. The justices affirmed that public employees do not give up their rights when they take a position in public schools. In this case, the coach's freedom of speech guaranteed under the First Amendment was upheld.
Each of these cases has had dramatic and long-lasting effects on how religious liberty is understood in the 21st century. Together, they represent a shift away from the strict separationist tendencies of the 1960s and 70s and have advanced the cause of religious freedom for institutions and individuals alike. Many factors influence these decisions. Chief among them may be a reaction to judicial overreach in the mid-20th century. Decades of advocacy and lobbying by religious communities also played a central role. And we cannot overlook the philosophy of Associate Justice Antonin Scalia, whose long tenure on the court shaped interpretations of the First Amendment, influencing both his colleagues and future justices.
The Supreme Court's record in the 21st century has thus far been favorable to religious institutions and freedoms. It has expanded the free exercise clause in education, public assistance, and the workplace. It has increased access for religious institutions to funding and benefits, ensuring they cannot be excluded solely because of their religious nature. The court has also protected private businesses that wish to operate according to their religious convictions.
The court has shifted away from earlier interpretations that sought a strict wall between church and state, moving instead toward a vision more in line with what the Founding Fathers intended. In doing so, the Supreme Court of the 21st century has turned the tide for the religious community and placed religious freedoms at the forefront of rights guaranteed under the Constitution of the United States, just as they were at the dawn of our great nation.
These decisions show the fight for religious freedom is far from over. But the Supreme Court's actions in the 21st century offer renewed protection for faith and public life. As citizens and communities, we're reminded that safeguarding these liberties requires vigilance, dedication, and an understanding of the principles that built our nation. Religious freedom remains a cornerstone of America, one that continues to shape our future. This is Faith and Freedom 250. Join us next time as we continue to explore the faith that built America.